Okay, so we're now recording. So let's start the meeting, and anybody else who joins, obviously I'll let them in. Okay, so off we go. Roll call. I have only one regret from Rob McGregor. I didn't think Gil was going to make it, but he is now. So thank you, Gil. Appreciate that. First order of business. This is the first meeting that Howard's returned to the fold since he left in the fall. So I want to welcome Howard back. And I've said this before, but I want to again thank him profusely for his dedication to the PRC over the many years that he was the chair, and an excellent job he did. So thanks, Howard. That's the formal thank you, and then we appreciate it very much. Is Hank? Hank has a guest he wanted to introduce. Don't see that happening. Okay, so yes, if that shows up, then we'll certainly welcome the guest and move on. Okay, so first item of business, or second item, I'm sorry, is the approval of the agenda. Can we have a mover for that approval? Okay, Howard, seconder.
I'll second.
Sean, thank you. All in favor? All right, thank you. Next, we have the approval of the minutes for our last meeting, which was January 11th, 2021. Again, can I have a mover to approve the minutes? Excellent. Seconder, okay, Sean or Howard, thank you. Peter, you're on here, so you're taking the minutes, so that's great. Thank you. Okay, so the next item, news, announcements, updates. I don't have any news or updates for this particular meeting. Does anybody want to add any items of interest at this point? Okay, good. Okay, business arising. So next we'll look at the updates on the justice-related committees. The first one is the Commons, Justice, and Human Rights. Howard is returned to looking after that committee. So Howard, the floor is yours.
Thanks, Miles. Actually, I was a little slow on the draw on the announcement or what's new. I just wanted to remind people to take a look at the newsletter that we send out every Sunday. The date can vary a little bit. It depends on Olivia's availability because she works full time as well, but we're doing it late Sunday evening. But there are two announcements there about funding opportunities. And so whether it's the Ontario government or a provincial government, other provincial government of which we've become aware, or the federal government, there's some funding opportunities there, one having to do with criminal records applications, which I think is quite important. Some funding has been made available to organizations, not-for-profit organizations, to assist people applying for record suspensions, pardons under the Criminal Records Act. There's another one from Ontario. Anyway, if people should keep an eye on that. Sometimes there's very useful kinds of announcements there that we try and highlight. Turning to the item on the Justice and Human Rights Committee in the House of Commons, this committee has met only once since the election. In September 2021, which is a little bit surprising and discomforting for me. They met on December the 16th, so just before the Christmas break, to elect their chair and vice chairs and to conduct some committee business, most of which is pro forma, motions to establish their subcommittee on agenda and procedure, a motion to retain analysts from the Library of Parliament to assist in their work, things of that nature. The thing of greatest interest is the election of the chair and vice chairs. Did you touch on this at your previous meetings, Miles? Of course, I missed December and January, but
yes, I announced the organizational meeting and identified the chairs and vice chairs. Good.
So just to add briefly, it's been such a while since I've appeared before this committee that I don't. Many of the people are new, but I note that the chair, Randeep Sarai, I hope I'm pronouncing that correctly, and the two vice chairs all are lawyers. So there's a vice chair, Rob Moore from the Conservative Party. He was first elected in 2004 and served pretty continuously from 2004 to 2015, was out for a term and then back in 2019. Rob Moore was part of the original Reform Conservative group, and his views in opposition were very tough on crime oriented, but he is a lawyer and he's a vice chair, and the other vice chair, of course, is from the Bloc Réel Éloi Fortin. If again, my pronunciation may not be correct, I apologize. All three of them are lawyers, which is generally a good thing for a committee that focuses mostly on legislation in the justice and corrections area. The other thing I wanted to note is a new member of that committee is Yasser Naqvi, who was elected this past September as the Liberal MP for Ottawa Centre, replacing Catherine McKenna, who had decided not to run anymore. You remember Kim, he was the Attorney General. He was a conservative, pardon me, he's a Liberal. I misspoke, so let me withdraw that immediately. He's a Liberal member of Parliament and was a Liberal member of the Ontario legislature. I think he served 3 terms there before the Liberals were defeated by the Ford government. So elected in 2007 and again in 2011 and 2014. He served as the Attorney General of Ontario, and prior to that as the Minister of Community Safety and Corrections. So some of you will remember Kim from trying to move things forward that I think were quite progressive. I'm a fan of his for what it's worth. I think he's an upcoming person in the federal parliamentary stellar heaven. I was disappointed not to see him have a more prominent role, but hopefully at some point he will. He's a very bright lawyer and very interesting man. So I won't dwell on that, but the structure of the committee is interesting. The Liberals seem to have a full control of it, even though they have a minority government. They have a majority of Liberal members on that committee, and that would bode well for some of their legislation to pass through. So that's the only meeting they've had. Their second meeting, which is extremely important, is scheduled for this afternoon from 3:30 to 5:30. And I'm going to highlight it for you because I think it's quite important. I wish Stacey Hannum were here, because Stacey has particular expertise in this area, and you'll see what I mean. The committee this afternoon, in addition to some committee business, is going to hold their first meeting on a review of the Protection of Communities and Exploited Persons Act, which is the Statute of Canada 2014, Chapter 25. What I just articulated, the Protection of Communities and Exploited Persons Act, is its short title. It was Bill C-36 in the 41st Parliament second session. So we're going back to 2014, which is the Harper era. The long title of the act is an act to amend the criminal code in response to the Supreme Court of Canada decision in Attorney General of Canada versus Bedard. So you'll remember that's the Supreme Court of Canada case that struck down 3 criminal code provisions dealing with prostitution on the basis that they violated Section 7, the liberty of the person. So essentially the challenge in Bedard was by 3 sex trade workers who brought an application for a declaration that those provisions were unconstitutional, based on the notion that they violated their security of the person because the restrictions didn't actually make it illegal to be prostitutes, but prevented them from running their business in a way that protected their safety. Okay. So they had to apply you couldn't solicit for prostitution. The restrictions that existed back in that time, 2014, meant that they were practicing their trade that wasn't actually per se illegal, but in ways that did not allow them to protect themselves from very aggressive and sometimes cruel, sadistic, and homicidal John. So the Supreme Court of Canada struck down those 3 provisions and suspended that declaration of invalidity for 1 year. The Harper government at that point came back with Bill C-36 in 2014. It received royal assent in November of that year. And again, that's the Protection of Communities and Exploited Persons Act, Bill C-36. One of the provisions of that act, Section 45.1, calls for a 5-year review, a comprehensive review undertaken by a committee of the House of Commons of those provisions, and requires that committee within a year after the review to table a report. So this is that review of the provisions of Bill C-36, and it will start this afternoon. The witnesses listed for this afternoon are from the Department of Justice, the Director General and Senior General Counsel of the Criminal Law Policy Section. Her name is Carol Morency, and one of her analysts, Natalie Levman, the Senior Counsel, who I know both of these women, and they're quite capable. After the Department of Justice testimony, there are three individuals testifying. One is Carolyn Botting from the Ottawa Police Service. The second is Jennifer Clayman, I'm not sure which, the National Coordinator of the Canadian Alliance for Sex Work Law Reform. And Sandra Wellesley, who is the Executive Director of Stella Montreal. The actual name is Stella Lamy de Memi. It's a sex workers' rights organization run by and for sex workers in Montreal. So they will all be appearing. The Bedard case is interesting. The Harper government's response, again, I wish Stacey was here because she appeared, I believe, on behalf of CCJ on Bill C-36 when it was going through. She's one of the few members of CCJ who was invited to participate in committee considerations under the Harper era, and of course her brief is fabulous. The problem with C-36 is it's asymmetrical in its policy approach. So basically the Harper position, government position at that time, was we are not going to make it illegal for a sex trade worker to offer their services, but we make it illegal for someone to buy the services. So they asymmetrically criminalized part of that transaction, which means, of course, the transaction again has to be conducted in secret, in ways that still don't allow the sex trade worker to hire staff or conduct their business in an establishment where they can secure themselves in various ways. So my guess is that there will be some fairly serious criticism of C-36 from that perspective. It will be interesting, I think, to see whether or not the House of Commons committee allows for a full review or tries to do a very perfunctory one. We'll know later on today what the Department of Justice officials, what their position or take on it is. But I think it's something we should keep an eye on. I certainly will keep you up to date as I report on the Justice Committee. But if anyone's in touch with Stacey, you might want to make sure they're aware of this. Irving, is it possible just to maybe send her a note to make sure she's familiar with this committee? She has tremendous expertise in research on the sex trade. In fact, is still conducting research on this very topic. And I think it would be wonderful to have her come to the PRC to talk more about this. But I'll do my best to keep you advised. Not a central area of an area that I claim any special expertise on, but this is an important parliamentary review of a piece of legislation that certainly has some sharp edges and controversial aspects. So anyway, I'll stop there, Miles, if that's, I turn the floor back over to you.
No, yeah, thanks, Howard. And Kyle will back me up on this. If we did want to get somebody, if Stacey wasn't available, I could probably get Christine Bruckert. He's a full professor in criminology at the U of O. This is her thing, and she was very, very much involved with Bedard at the time. And you're quite right. Harper put in place the Nordic, what was referred to as the Nordic model, which was to basically criminalize the purchase of sex. And exactly as Howard was saying, the argument against that, of course, at the time was, and it's borne out, is that the three provisions of the criminal code that were struck down by the Supreme Court and Bedard all related to the factors of safety and the elimination of available safety measures like carrying on the sex trade in your own home, which was previously referred to as a body house, those kind of things. So yet clearly the Nordic model, doesn't make it any more safe than the provisions of the code that were struck down by the Supreme Court. And the thinking at the time after 2014 was that it was fully expected, and I don't think it's happened, is that another case would wind its way to the Supreme Court again, and it takes about 7 years after someone's charged for that to happen, that would basically attack the provisions of Bill C-36 on exactly the same grounds that Bedard did originally back at trial in 2011 or 2012. Anyway, Howard, thank you for that. Again, if Stacy's not available, I'll gladly get Professor Bruckert to return. Yeah, Howard?
Yeah, no, just one. Lawyers have too many cases in their heads, and you, Miles, you had said Bedard, but it's Bedford.
Bedford.
And just to cite the neutral citation is 2013 SCC 72. Sorry, let me just say that clear. 2013 SCC 72, and it's available on the Supreme Court, the Lexis SCC judgment site. So you can go and have a look there. It's a very interesting case, but Bedford. So
yeah, absolutely right, Bedford. So thank you for that. All right, guys.
Pardon me, Miles. You said it was on at 3 today, Howard?
yes. Yeah, so let me just, it's 3:30. I think. Let me just scroll here. 3:30 to 5:30.
Okay, I'll drop a line to Stacy if she can listen in or whatever.
I should already be aware of it, but it connects very squarely with her expertise. But as Miles has said, Christine at U of O criminology has direct and tremendous expertise in this as well. And Kyle may know of people at Carleton as well who are watching it. So,
okay,
super, thank you. Okay, next committee is the Commons, Public Safety and National Security, Rob and Gil. So any thoughts on or any updates on that?
Rob and I have an arrangement, Miles, and normally if he's not going to do it, he lets me know when I do it, but apparently he's gone and done it, and he sent you a note indicating he will email it. So right. I thought he was doing it, so I didn't look at it. So I have nothing for you today.
Not a problem, Gil. Thank you. Yeah, I about 15 minutes before the meeting, I got an email from Rob indicating he was going to send an update because there has been some activity in this committee, but I didn't receive it before the meeting. So I'll have to bring that up to date at the next meeting. Or if I get his note, I will circulate it to the PRC. Okay, the Senate Legal and Constitutional Affairs, Sean and Brendan.
So I will be taking the lead on this one. And thanks again to Brendan for handling last meeting. So definitely great. We've got a meeting coming up tomorrow at 4:15 Eastern for people who are around. And that's going to be focused on Bill S210. So that's looking at restriction of young persons' online access to explicit material. And so the witnesses that'll be coming out, well, the sponsor for the bill is Julie Meville. Wow, I can't read my own writing, I'm sorry. Well, there's a dash last name with a D. I can check that in just a second. I was scribbling down some notes while I was going today. So the witnesses, they're going to be Dr. Michael Geist, he's a professor at University of Ottawa Law School, as well as CBA Crim section. There's Kevin Waistell, and Brian Hurley is going to be attending as well from the Canadian Council of Criminal Defense Lawyers. And so the meat of the bill is the purpose of the bill is to protect mental health of young people, as well as to protect young people, particularly women, from exposure to sexually explicit material, and to deter organizations from using this material to make commercial benefit. So it outlines 2 offenses. First-time offense, max fee of $250,000, and any second offense and greater would be a max of $500,000. It lists 3 defenses that are available. So if the organization that were to be making use of this material were to be able to demonstrate an age verification method, that would be an applicable defense. There could also be a legitimate purpose for making this material available. So that can include purposes of science, medicine, education, or the arts. And third defense would be if reasonable steps were taken if a notice was issued by the enforcement agency. The minister has power to be able to designate one of those agencies, and I'm not exactly sure which agency that might be. They could use one of the digital custodians or maybe something from the RCMP. But the most interesting component of the bill, I guess, is that if the notice is not acted on, an application can be made to the federal court. And with that application, they can issue an order on that application to basically fulfill the obligations under the notice. But the most interesting part of it, sorry, I guess I'm getting ahead of myself, too much coffee today. They can name the internet service provider and bring them in as a respondent, and they can issue orders to the internet service provider to basically cut off access for that commercial entity. So that's definitely a positive change, and we'll be able to, I guess, improve enforcement measures based on compared to what we have right now. And the bill went through first reading on November 24th. And well, I didn't check when the second reading is coming up. I guess it's at committee. So that's the information that I've got about the bill right now. Does anybody have any questions about that?
I just thought it's so her last name it's Deschaine. So Julie
Thank you, sir.
Miville Deschaine.
Thank you, sir. I appreciate you checking that out.
My pleasure.
Mhm. Oh, one thing that I did want to mention about this, it seems to me like this is likely related to general movement across the country. In different regions, it varies. But looking at non-consensual sharing of sexual images, it's been coming up quite a lot from what I've been hearing, focused a lot in the prairies and on the west, but I might be missing some data of what's happening in the east. But I know that it's very vogue right now and action is necessary. So I imagine that it'd be related to recommendations on that front.
I just wanted to add one quick thing. Sean, that was a wonderful explanation. I just thought that I would add they're currently in England. I don't know if it is all over for all of Great Britain, but anyway, they're debating legislation about young people's access to pornography online and things like that. So they're having very similar debates. So if anyone does end up writing a brief on this or speaking, there's interesting debate going on currently in the UK.
And I think that there's some of it happening in California too. But yeah, great addition. Thank you.
Well, thank you, Sean. Thank you, Brendan. Any comments or questions on this? Okay, and lastly, for committee work, I've stepped in to replace Francois on the Senate Human Rights Committee. It's had one meeting, apart from its organizational meeting. It's dealing with Bill S-211, which actually isn't one of the bills that we follow or that we're following, but it's a bill, it's an act to fight against the Fighting of Forced Labor and Child Labor in Supply Chains Act. And so they've had a meeting on February the 7th, just to basically hear from proponents of the bill. It's a private member's bill. I don't have anything. I didn't watch the 2 hours of the meeting itself. But again, because it wasn't on our justice agenda, it's a human rights issue. I didn't do much more other than record the fact that the meeting has taken place. Does anybody think that, and I'll certainly do this, do you want me to follow this bill for the purposes of the PRC? Okay. All right, that's fine. Thank you. Okay, the next item is item B under business arising. It's the relates to Criminal Cases Review Commission, now or to be known as the Miscarriages of Justice Commission. Howard did a nice job yesterday, or I guess on Sunday, with the newsletter highlighting the fact that the full report has now been released. Harry Laforme, former Justice of the Ontario Court of Appeal, released it publicly. We've gone through this in a fair amount of detail in the last couple of meetings. When it was originally reported, the executive summary came out. We reviewed the details of the executive summary at PRC. I think it was in our December meeting. So I don't plan on reviewing that much more detail, other than the fact that it's obviously a good thing to get the full report out in the public domain. This report, it's enlightened, it's progressive. It proposes the establishment of a new Miscarriages of Justice Commission to essentially replace the Minister of Justice's prerogative under Section 696.1 of the Criminal Code, which is basically the provision to exonerate those who believe they've been wrongly convicted and most often incarcerated. So this whole Miscarriage Commission has been put forward. It's actually it has the broad support of the current government. It was contained in Minister Lametti's mandate letter from the Prime Minister to basically establish this commission. The commission did a lot of research. We were part of that. The CCGA, I made a representation on behalf of the CCGA together with my own work to the commission, and it's a very promising thing on the horizon. It's basically going to broaden the grounds upon which those who believe they've been wrongly convicted can in fact apply. It takes away from the application process the requirement to prove essentially factual innocence, which is an incredibly difficult thing to prove, mostly in hindsight. It looks to basically have 9 commissioners, and 9 commissioners including one that is Indigenous and one that is Black. It addresses systemic racism in the criminal justice system and aims to record the applications that do relate to that form of racism. The current system in place, which is run by a somewhat of an ad hoc committee in the Department of Justice called the Criminal Cases Review Group, they haven't kept any stats whatsoever on those who apply for what's now called a ministerial review. They don't have any data whatsoever on items of race and discriminatory indicia. So, obviously it's important that that is included, because we all know of the incredible disproportionate number of, for instance, Indigenous Canadians in our penal system. So anyway, I won't say much more about this other than the fact that it has now been reported fully. It's in the hands of Minister Lametti and whoever is working on it for him to come back to see what they're going to do. What we expect it to do, we being all of us who have been involved in this process, expect there would be introduction of a bill, by the minister. So, a bill in the Commons to create this commission. And of course, obviously, the provisions of the legislation will hopefully implement most, if not all, of the recommendations that the commission or the committee studying this proposal with Justice Laforme has put forward. Any questions that I can answer in this regard? Again, we've talked about this at some length before. Okay. All right, so we can leave it at that. That's where we stand, and if anything else obviously comes up before our next meeting, I'll certainly put it in the next agenda. I truly think that the next item that we'll see on this issue will be, in fact, the introduction of a bill in the Commons, and obviously that'll make it to our agenda as well. Okay, items C, D, E, and F are all waiting briefs on our agenda there, and you all have them there. We've discussed them again in prior meetings, so I don't plan on going over them at this point. I don't think we have anything new regarding the items that are the subject of those matters on the agenda, unless somebody has any questions or updates that I don't have. Item G on the agenda is the invitation letter for consultations on facial recognition. And this is a matter that Peter can respond to. He's going to prepare comments to it. And I believe Lynn has corresponded with Peter on this as well. So we can hear from either or Peter and or Lynn on this particular issue.
I might as well speak quickly here on this. Yeah, it's being prepared. The bill the consultation primarily focused on police, which is a really interesting thing from my perspective, simply because it doesn't even touch CBSA or CSIS or any of the other components or agencies within Public Safety Canada, which is really fascinating because they both are using facial recognition software and practices to enable figuring out who's who in the zoo. That being said, Lynn and I are going to have a conversation on Thursday at 3 p.m. Alberta time. We had an interesting time lapse here because we were talking in 2 different time zones, and so we finally, as Lynn said, the plans come together. We are meeting on Thursday afternoon at 3 my time. Saw a little hand going up, and so we will then figure that out. What I'll do is I'll undertake to have something from Lynn and I in time for the next PRC meeting in where is it, March, so that we actually have documentation before the committee, and it'll be before the committee, won't be on the day of the committee.
Excellent, thanks, Peter. Lynn, did you want to add to that?
No, that's perfect. Thank you so much.
Okay, wonderful, thank you. Okay, the next item H is was the prospect of the CCGA. It's the board's decision in joining the Fresh Start Coalition. Again, we've touched upon this numerous times in past meetings. This is the coalition of about 60 justice groups headed by the Canadian Civil Liberties Association, essentially, to basically put into place a spent conviction regime to replace the current record suspension program in place at the federal level, which again, would then obviously rescind the Harper amendments to what used to be the pardon system that was in place for those with a conviction. And the prospect of it was obviously to make it as easy as possible to remove convictions that have stood the test of time, in that the convicted offender basically has lived a crime-free life for whatever periods of time were appropriate. Which the coalition doesn't say this, but the talk basically is 2 years post summary conviction and 5 years post a indictable conviction. Having said that, we've gone back and forth with the board on this issue. I've attached for your information the correspondence that we've had subsequent to our last meeting. So what I did is I wrote back, and this is on the premise of Matthew's motion in our last meeting, that we go back to the Fresh Start Coalition and advise them that we had concerns with respect to 2 items, essentially relating to what they were proposing. The first one being that there was no exclusion for a conviction to disappear based upon essentially crimes having a sexual element, so sexual offenses dealing with women and children for the most part. So that was a concern, and is a concern of the board. And the secondarily, the board also had concerns with respect to the length of time that would be used for the convictions to become spent. So I basically sent those concerns back to the coalition. Abby Deschman at the CCLA, it was the one that I sent that concerns to. She quite kindly responded very quickly. So I've included in your materials her response dated January the 18th to those 2 concerns of the board. And she's basically set out essentially that the response with respect to the exclusion of sexual offenses is that, yes, they agree that they don't exclude any offenses from the prospect of being basically expunged, but they do obviously keep in place the vulnerable sector check that would basically bring to the attention of anybody who's concerned that in fact there would be convictions of a sexual nature that would still stand in place. Her response on the period of time for passage is that the coalition doesn't take a position on a period of time. So their proposal doesn't in fact address that actually. But they do obviously take a position that the current system in place, which is the system in place everywhere except Ontario and British Columbia, which both had constitutional challenges to the Harper amendments, that 5 and 10 years is far too long for convictions to be in place to address the stigma that it obviously attaches to those convictions. Anyway, having said all of that, and after discussions with Irving, and Irving, I invite you to jump in here any point in time. Our position basically is that we obviously recognize the position of the board is that they stand by those concerns, as was published in our brief to the government last year on Bill S-218, I believe it was, which is Minister Pate's bill. It's the brief that I prepared as amended by the PRC and the board. Irving, anything to add to that?
I don't think so. I mean, we've discussed this, I don't know how many times now, particularly starting in particular with the with our take on Kim Pate's bill, and the brief that was prepared, the latest one, I think speaks for itself. The members of the board voted at least twice now on the issue. We're on the record. I'm not sure we have anything further to add at this point in time.
Yeah, thanks. So the long and the short of it is that that the CCGA is not joining the 60 other odd groups that are part of the coalition. It stands by its a position that we've made very clear to the coalition, and that's about it. Any comments or questions about that? Okay, good, thank you. All right, let's see now, before we move to new business, I apologize. At our last meeting, we agreed that we would add a new item on the agenda as an ongoing item. I didn't do that in this agenda, so it's my error. We discussed about, when we discussed alternatives to incarceration. And Matthew brought to our attention that it's been a position that the CCGA has had for probably 20 odd years, maybe more. It has continuously over the course of time made known its position with respect to what should be alternatives to incarceration that exist at various times. Matthew indicated that he and Kyle may put something together. This would be a letter that we would send, I presume, to Minister Lametti, perhaps to Minister Mendocino as well as Minister of Public Safety. That would make sense. And that was something that would be on our agenda and ongoing. Kyle, did you have a chance to talk any further to Matthew about this?
Sadly, I did not. So I'll treat this as a friendly reminder, and I'll send him a note sometime today. The only thing I would add, and this is my angle, but I mean, I'll definitely discuss with Matthew in more detail. I prefer to take the lens of not just alternatives to incarceration, but alternatives to criminal justice system participation and involvement more generally. So that's kind of where some of my initial thinking and advice lie, but leave it to Matthew and I to discuss and we can report back at the next meeting.
Great, thanks, Kyle. Irving, you had some comments last time we discussed this. Did you want to add to them?
No, I don't think so. I thought I was, what I'd indicated last time was I was waiting for Matthew to put together just some kind of a framework letter, and then I could, fill in, add some meat, and maybe we can get some research done in the office for the kind of the stuff that had been prepared and shared and communicated in the past. Problem is, obviously, those documents are hard copy stuff. We don't have them in digital electronic form, but I would wait for Kyle and Matthew, and we'll take it from there, I think.
Sure, that's great. So we'll return to this on the next agenda. I promise to actually have it as an item on the agenda. Any comments or questions about that? Yeah, Howard?
Yeah, just to add the related point, I think that Bill C5 is the government's reintroduced bill on repealing some mandatory minimums and also repealing some of the restrictions on conditional sentences. Now you will all know in the criminal code, there are very few alternatives to incarceration, probation, fines, and the conditional sentence, which has a long history, first of being fairly broad and then of being narrowed by successive governments of both political strains. This is the first time a government has sought to reduce or eliminate some of the restrictions on conditional sentences. So I see this as very much a move towards expanding an alternative to incarceration. That was its express purpose when the conditional sentence of imprisonment was first enacted. Brendan and I are working with my two pro bono law students at U of O to do a brief on C5. And a component of that brief will include discussion of the conditional sentence and a description and analysis of what's in C5, which will proposes to repeal some of the restrictions on conditional sentences. Now, C5 has not finished second reading yet, so it's not prominent. But I'm hoping that with our two pro bono law students, Naomi McDeer and Claire Whitty, and Brendan and I, that we will have a brief, hopefully for the next PRC meeting in February, a draft brief dealing with those two areas, as well as another thing included in C5 is a pious wish in legislative form that Crown attorneys and police will divert some possession of drug cases out of the criminal code. But I think Kyle's point is very well taken. I mean, I want to add that there is a position paper on the CCGA website on the conditional sentence, which very much takes the position that the CCGA supports alternatives to incarceration. So you might want to look at that position paper. It was done a little while ago, but it's still worthwhile reading. I think Kyle's point is a good one. There's a big difference between diversion and alternatives to incarceration, but alternatives to the prison, to the whole criminal justice system, I think is in a very important area as well, whether it's combined in the letter that Kyle and Matthew are preparing, or whether we treat it as a separate issue. But the distinction there is important, but both hopefully would achieve some of the same thing, which is to reduce the destructive impact of the criminal justice system, primarily through incarceration, which we know, and anyone who's following the COVID rates in federal and provincial prisons will see this. But I think these are good issues, and I look forward to seeing what Kyle and Matthew come up with. Stay tuned for the Bill C5 brief. Brendan's helping us with the criminological parts of that. My law students are doing some of the more legal side of it. But that's alternatives to incarceration is an underdeveloped area in criminal justice policy, as is adult diversion, youth justice diversion. There's all sorts of it that exists across the country. I won't say that there's enough of it even there, but in the adult system has been very reticent, very slow to develop alternatives to incarceration and alternatives to the criminal justice system. So that's my comment. Thanks.
Yeah, super. Thanks, Art. Okay.
Miles, if I can just add a comment. An angle that you may want to add in is the criminalization of individuals with mental health issues. We did quite an extensive study across Canada at St. Leonard's Society and CCJ, going back, I think, about 10 years, perhaps even a little bit more than that. There were hard copies in the office, actually, Howard. And we visited across Canada. We went to Vancouver, Halifax, Toronto, Kingston, and I can't remember the other city off the top of my head. And what was one of the conclusions was, and what was underlined, was the importance of trying to avoid the criminal justice system contact with those who have mental health issues. And we know that's a significant portion of the offender population, right? At the Corrections Canada, you're looking at probably 25–30% at any one point in time. I suspect it's probably even higher at the provincial level. So that's another, where another subpopulation, if you like, where you want to avoid criminalization and contact with the system, which unfortunately very often lends to actual incarceration.
Sure, absolutely. Yeah, if the purpose of Matthew's proposal as forward last month is to essentially bring to this government's attention all the work that the CCJ has done over the decades on this bigger issue, then I would think that it's going to be a substantial effort before it actually gets polished off and presented. So there you go, Kyle. That's there's something that you can just get your teeth into. Okay, so new business. So this item was on the last agenda, but we didn't get a chance to discuss it. Sean was absent, but is here today. So that's we're grateful for that. So the first one is the CIAJ annual conference. That's the Canadian Institute for the Administration of Justice annual conference. There's a link to the meeting and the items discussed. Sean, you were going to report to us, so if you could do that now, that'd be great.
Yeah, so the conference is really is a great opportunity to attend. One of the benefits of having it digital, we also had a lot of the law students at Robson Hall go there in person from Manitoba Indigenous Law Students Association, so they definitely had a stake. And really great experience. You may know that Minister Lametti, he shared, I think, some points on his mandate at that event as well. There were 8 sessions that happened over the course of 3 days, and the focuses were reviewing the experiences of survivors from residential school and people who have been affected that are Indigenous by the justice system generally. So one notable in there was Phil Fontaine, who you may know. He's from Manitoba and has done a lot of great work in that sense. The second panel was looking at a review of the legacy and impact of truth and reconciliation here in Canada. So looking at access to justice, decolonization, and my writing is just terrible these days. And preserving and restoring languages. I wanted to mention that one because at the University of Manitoba, we do get to do some work towards that end with the National Center for Truth and Reconciliation. And one thing that I forgot to mention at the beginning, something that's really fitting about holding this event out in British Columbia is that it's unceded territory, and they do have a bit of a unique relationship with Indigenous law, as well as being able to really take the lead in being able to put together objectives and also to really make those things happen across the country. So really encouraging for our Manitoba students, because we've got a large Indigenous population here, and a lot of things that they were able to take back home and to make change. And one thing that I'll mention just from what we talked about in the meeting today is the pardon program that Howard mentioned is in the newsletter. We set up a clinic that's going to be doing helping people apply for those pardons, and as well as to demonstrate status and access all the government resources that are available there as a function of what we learned at this conference. But continuing on with the content, hope I'm not going on too long. So third instance was looking at Indigenous laws and their relationship to the justice system. So UNDRIP, section 35 of the Constitution, so looking at Aboriginal rights in particular, and the potential that is there to bring in Indigenous legal orders, as well as like oral traditions and other things of that nature. So really encouraging experience there. And a couple of noteworthy folks were Val Napoleon, and she is the program director of the JID program, so Juris Doctor in Indigenous Law. I can't remember exactly how that plays out, but being a director there, it's a very unique program that is here across the country. And she works closely with John Burroughs, who is a well-known academic in this area of oral tradition and Indigenous legal tradition generally. Fourth panel, student panel, they were talking about bringing cultural competency into different law school curricula. So interesting to learn some of that and to bring some of those lessons home. Next was child welfare and reform. And as I'm sure we all know, there was the biggest settlement that's ever happened in Canadian history related to the child welfare system. And fortunately, Dr. Cindy Blackstock was there. So it was good to be able to learn from her perspective on it. And I think that carried over into the work that she was doing with the government of Canada. Next, so looking at Canadian treatment of Indigenous offenders, likely the most relevant to the work that we're doing here. So they reviewed a couple of noteworthy things that stood out was the underutilization of body reporting. And that's been somewhat systemic across the country, and particularly where there's a high concentration of Indigenous offenders. So that was a bit surprising, and I got to learn a little bit about that and why, basically a discussion about resources and why it's not being invested in appropriately. So that was a little bit unfortunate, but good to be able to highlight those kinds of things. At that panel, there was our good friend Kim Haight, so great to be able to hear from her, and Kent Roach from the University of Toronto. Sorry, I got a little jumbled with my notes one more time. So seventh panel was looking at the approach to self-government, and as well as First Nation, Métis, and Inuit governments. The Manitoba Métis Federation, for example, got to speak to some stakeholders that were there. They've made a lot of great gains in that direction as well. But at the event, there was noteworthy Mary Ellen Turpel-Lafont. She is a director at the Peter Allard School of Law, which also does a lot of great work with Indigenous clinic work and other things like that. Got to speak with her afterwards and really laid the foundation for implementing her own clinic at the University of Manitoba. And the last session was looking at inquiries and reporting on Indigenous peoples and their relationship to systemic racism. So looking at murdered and missing Indigenous women and girls, as well as the calls to justice that resulted from that report, and the calls to action coming from TRC generally. I didn't have too many notes on that, and I'm sorry. I was kind of fading out by the end of the session, but still great to be able to attend and learn from everybody there. And just noting that it was great to have closing remarks come from Colleen Suchet, who is a justice or judge with the Manitoba Court of Queen's Bench. So we had some good representation, learned a lot of stuff, and really great to learn about the differences of the Indigenous relationship, where in an unceded territory, a lot of gains that can be made and a lot of a very different context compared to some of the other spaces that we have here in Canada. But those are the points that I wanted to raise. Any questions about that?
No, that was very, very informative, Sean. Thank you very much.
Happy to.
Appreciate it. Okay, the last item of new business was Irving received an invitation to participate in a national consultation on human trafficking, and I believe John is going to take up the mantle to carry on with that. If you could say a few things about it, that'd be great.
Is John on?
No.
Miles?
I don't see him.
No. Well, I sent it over to John Winterdyke, who's got a lot of expertise in the subject matter. And he's traveled in all parts of the world, actually. And those of you who attended the last CCJ Congress will remember that he did a presentation on that very subject. So he said he's going to get involved. I think he was already contacted prior to that, but now he would be representing CCJ as well as himself, I guess. And I haven't heard anything subsequent, though.
Yeah, I'll follow up with him before our next
He may be
meeting.
traveling. He does a lot of stuff overseas. So
Right. Okay, I'll contact John before the next meeting and see if he has anything to add for this item when we return in March. Thanks, Irving.
Okay.
Okay, so that's it for our new business. So moving on to criminal justice bills. Now, Parliament only
Just a
resumed.
second, Miles. Sorry, Kyle had a question in the
Oh, I'm
chat.
sorry, I didn't see that. Kyle?
Apologies, I'm going off script, but Irving, when I was curious, when I was hearing you speaking, was there any updates from Statistics Canada on the various kind of engagements that were taking place?
nothing.
Okay, thank you.
You're welcome. Are you surprised, Kyle?
Deeply.
Okay.
Yeah.
All right, thank you, guys. Okay, back to the bills. Now, the Parliament only resumed January 31st, so it's a week ago. There's not a lot that's happened with respect to any parliamentary activity, either in the Commons or the Senate. So I've basically indicated with all the bills, if there's been any change or no change, and as you can see, there's virtually no change in almost everything. I'll highlight the ones that there is a change. I did note in Bill C5 that the action is Howard's pro bono students and Brendan working on that. So that just reflects what Howard said earlier. So thank you for that. So no change on everything in the Commons, basically, except regarding Bill C229. I didn't put that in the materials, but I will add it. And Bill CC29 is a bill introduced a few days ago, basically with respect to an act to amend the criminal code banning symbols of hate. So the preamble to the bill, I'll just tell you quickly what the preamble is, and then tell you what the intent of the bill is. And it's important to keep in mind that as well, just a few days ago, the government announced that it will be introducing a bill in the Commons relative to hate crimes and what have you. And the Bill C229 is a private member's bill. So I see this as going to be a governmental bill very quickly. But essentially the preamble is this: whereas Parliament recognizes the importance of preventing all forms of hatred or violence against any group that is distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, gender identity or expression, or mental or physical ability. And whereas Parliament acknowledges past atrocities and violence committed against such groups by persons or organizations whose symbols, emblems, flags, and uniforms continue to this day to promote or incite hatred and violence. And then it goes on to discuss, of course, and this is relevant to the truckers, what's going on in Ottawa, is the use of swastikas openly, or the Confederate flag, or KKK insignia, all those kind of things. So this private members bill is directed, against obviously any use of those symbols or emblems in public that incites hatred and what have you. So that's the intent of the private members bill. At this stage of the game, it's just been introduced, so there's nothing that has been discussed at this point. And I would presume that all of that will be subsumed in what the government brings forward as a government bill very shortly. Any comments about or questions about that? It's virtually the only piece of legislation that's been introduced since our last meeting. All right. The only other thing, and again, there's no change in any other bills in the Commons or Senate that we discussed previously. The only one I refer to here is Bill S213, an act to amend the criminal code regarding the independence of the judiciary. And the action on that, we talked about this last day, that Olivia didn't have time to prepare a brief, but Francois had prepared one on a prior version of the bill, and Irving was checking the whereabouts of where that may have gone. So did you have the opportunity to follow up on that, Irving?
I did, and I'm trying to remember the answer to your question, quite frankly. I don't think it progressed. But let me double check. I'm guessing now. I know I checked it out. I know Olivia did not, that's clear. Olivia didn't have a chance to do it. And I have to check the whereabouts of Francois.
Thank you.
Uh,
We'll
and
come
then-
back to that, Irene. So thanks
Yeah,
very
yeah.
much. Yeah, Howard.
Irving and I had a conversation about it, and I know he's just he's so busy with the Congress planning that it's hard to get on top of these things. But I think there was a bit of a confusion there, in the sense that what Francois was working on was a bill having to do with independence of the judiciary in the sense of being the legislation trying to require them to take training. The Kim Pate bill, which basically has now been transferred to, reintroduced and transferred to Senator Jafford, is a bill about mandatory sentencing provisions. I think part of what causes the confusion is the use of the term judicial independence. But I think Kim Pate had that essentially because what she was trying to do, the bill is aimed at increasing or restoring judicial discretion in the sentencing process with respect to mandatory minimums, but also mandatory consecutive sentencing. I don't think, I mean, we'd expressed an interest on doing something on Kim Pate's bill. Olivia was going to take it on, but we know she's got about 3 jobs right now. She's very, very busy with the newsletter and her full-time job and in the public service and all of that. This connects closely to the C5 bill. Obviously, Senator Pate's approach is much broader and more inventive, more inclusive, more progressive than C5 introduced by the government. I know Senator Pate has passed this to Senator Jafford, but in the past, Senator Pate had repeatedly tried to get the government to take on this broader approach to counter mandatory sentencing writ large. If we get a chance, Brendan, we haven't talked about this, but if we get a chance in the brief on C5, we might try and refer to that. There's also a private member's bill before Parliament proposed by Elizabeth May that would propose the elimination of more mandatory minimums than C5 does. So if we get a chance, we will try and refer to both of those private members' bills as comparison points. The only caveat I would add is that we have so much at this point in the C5 with the Controlled Drugs and Substances Act, the Criminal Code, mandatory minimums, the conditional sentence, and the diversion for possession of drug charges. I don't know if we'll get a chance to do that, but Senator Jafford's bill is worth looking at, again, because it touches on not just mandatory minimum penalties, but mandatory consecutive sentencing and other sorts of things. And Kim Pate's position, and I think it's reflected in that private member's bill that Senator Jafford now is sponsoring, would also eliminate the mandatory minimums for homicide, which, as you may know, is a much more controversial provision. And in the sense of focusing on the prescribed parole ineligibility period. So anyway, just a comment on that. I think there was a little confusion between what Francois was doing, Olivia was going to take on, but just simply didn't have the time to get around to it. But it does relate to our C5 brief. And when we bring that to the table, hopefully at the March meeting, maybe we can have a conversation about how strategically to connect with some of those other bills. I don't want to foreshadow it, but I think that the position we will recommend in the draft brief on C5 is the federal government should go a lot further. And those are 2 models, both the Elizabeth May's bill, but also the private member's bill, the Senator Pate, Senator Jafford bill. So.
Wonderful. Yeah. So based on that clarification, thanks, Howard. What I will do is I'll remove the references to Olivia and Francois relating to this particular bill. I'll take that out of our agenda in the minutes. So that's gone. So Irving, we don't need a further update.
I'm trying to clarify my own mind. I think what Francois did the piece on compulsory education for judges, is that the one? and that went forward, right? That's correct. All right. There's a lot.
I'm glad you clarified your mind.
Oh, God. I mean, there was a lot of judicial action, a lot of judicial activism.
We're good. Thanks, guys. Okay,
Thank
nothing further on any bills. There's nothing been happening, and that's obviously going to change for our next meeting because the committees will be meeting for, the next 3 or 4 weeks before we reconvene. Before we adjourn and thank everybody for attending, we have a guest who's joined us. It's Mark, and it's Mark. I believe it's Medgiyesi. I apologize for his last name. You are Hank's invitee to this meeting.
I am, thank you. And my apologies for being late. It was passed on to me that the meeting was at 10 o'clock Pacific. And so here I am, but obviously having missed everything.
Well, you're certainly welcome, and we thank you for joining us. How about we just confirm for you that our next meeting is March the 8th at 12 p.m. Eastern Standard Time. So an hour earlier than your time. So if you could come back with us, then we'd be pleased to hear from you and have a conversation.
Excellent. Well, and my apologies again, and thank you for the welcome.
Oh, you're very welcome. Anybody else have anything for the PRC before we adjourn? Irving?
Maybe just not particularly or directly related to PRC, but just perhaps new business. We've closed the door to new submissions for Congress. I can tell you we've received 110 submissions. And we've started, it's a laborious process like I haven't seen in a long while, quite frankly, because of all the intricacies of it and so forth. We've started communicating with the potential presenters at least, and so far everybody's happy with what we're suggesting to them, but it's going to take a while. And of course, the whole thing is dependent upon the health of the world. And hopefully things will come back to what was once a normal scenario, right?
We certainly hope so.
It's looking good. And by the way, I should say, we've received submissions from somewhere in the neighborhood of 25 different countries.
Wonderful.
Yeah.
Wonderful.
So hopefully it should be a great success, again, assuming people can come and attend and enjoy and meet people from all across the globe.
Thanks, Irving. Howard, you had something else to say?
Just a quick technical question, if I can, and I apologize. Did you say Peter was doing the minutes for the meeting?
Yes.
Good. Peter, I don't have a written presentation on the Justice Committee, but I had notes. Would it help you for me to send those notes to you?
It sure would. Thanks very much, Howard. That'd be great.
There's more in there than you'll need, but it just will help with the names and all of that stuff. So I'll send it to you after we get off.
Thank you very much.
Very good. Thank you. Anything else, folks?
I think Kyle had his hand up.
I'm fine, thank you.
Okay, thanks, Kyle. All right, guys, thank you very much. We'll reconvene on March the 8th, same time, same channel. Thank you, everybody.
Thank you.
Okay.